Please, the little man with the mace.
Members, the House and Committee resumes its consideration of the Taxation, Annual Rates Returns Filing and Remedial Matters Bill. And members, before the dinner break, we were debating Part 3. The Honourable Clayton Cosgrove has the call. He has about 8 seconds of his 5 minutes expired, so he's 4 minutes and 52 seconds.
Thank you, Mr. Speaker. It was indeed, sir. It was a short call. I think even shorter than your colleague, the other chairman, who was in the chair at the time, sir. In metaphorical terms, in good humour. Look, I want to address a number of clauses in Part 3. And I know the Minister and the Chair will be ably prepared to answer some questions. Specifically, these provisions deal with the filling in. If we go to 104 through to 106, there are a number of provisions here excuse me, that deal with the electronic and otherwise filing of forms. And the aim, I'm advised, is that, as is with many tax bills that flow through the FEC, was an attempt to reduce compliance costs of taxpayers excuse me, and to make inland revenue more efficient by moving from paper to electronic services. I would note, though, and it'd be interesting if the Minister could provide some background to this, that there's still a gap in the inland revenue system, in that if you are filing, you get your personal tax statement, it will allude to salary and wages. It will also take account, it doesn't take account of interest paid on bank accounts. And I had, some years ago, I inquired of officials why this was, and it's because of the archaic computer system that we still have an IRD. So you have this bizarre situation as this bill tries to gain some efficiencies within the department, where if you request your personal tax statement, you align that with your RWT certificate, resident withholding tax certificate. The two don't match up, even though the banks have transferred, if you're on the right tax code, which most people are, transferred your interest from your RWT from your account to the IRD, but for some reason, because of the archaic computer system, they can't then reproduce that as part of your personal tax statement. So what you're required to do, as I'm advised, is either assume the revenue's got it right and there hasn't been a mistake, which is probably in about 90% of cases if you've got the right tax code, or if you want to be safe, you've got to ring up your bank, get your tax certificate, advise IRD in writing. IRD then reconciles both on paper and produces another tax statement with the correct amount in, even though IRD has got the money. And I did ask an IRD official, given that the banks are compelled to transfer the funds from your account, the RWT, to the revenue, surely there's a more efficient way, given they've got the money, for the revenue then to produce a piece of paper that says, here's your wages and salary, and anything else, here's your personal tax statement, and it will include money that we, the revenue, have already received from the bank. But apparently this is a sheer impossibility. It can't happen because there needs to be some reform or some change, to the IRD computer system. So my question to the Minister is, given the wonderful things that are contained within 104, 05 B, C, D and 106, are there any moves afoot to deal with that basic anomaly where the revenue receives the money but the revenue can't actually reconcile the amount it received from an individual's bank account and have it reflected in their personal tax summary without going back and that personal business having to go back with their certificate from the bank and go through the motions again? Can I also ask the Minister, in respect of clause 104, which one could nominally, sir, perhaps refer to as the John Banks clause, perhaps, because in 104.1 it states the following: where information contained in a taxpayer's return has been transmitted by electronic means in the prescribed electronic format, in accordance with section, I'm sure the Minister's familiar with this, section 36, the taxpayer shall retain or cause to be retained A, the return in the form of 1, a signed hard copy transcript of information transmitted. Now, my question, given that there has been some controversy in recent days, I can see the National Party members have sort of perked up and have taken this very seriously. Given there has been some controversy in recent days over whether people who sign forms read them, retain the notion in their brain that they have signed that form and have a memory of signing that form, Mr. Chair.
Honourable Clayton Cosgrove.
Given that that's a normal human biological and mental practice for 99.9% of the populace, apart from one person from Epsom, what would be the penalty regime if they... I'm sure Mr Goldsmith, I see him taking as the chief biographer of Mr Banks and person drafting his obituary as we speak, volume 2, what would be the penalty if somebody acted in a fraudulent way, i.e. did not retain, Minister, the correct documentation or signed that documentation, could not remember the name they used in signing that documentation, very sort of Day of the Jackal, isn't it? And, or could not remember or did not read the documentation that they signed. Would that absolve them, and I'm sure the officials will be poring over the statute books as we speak, I'll come to them in a minute, as we speak, what would be the penalty regime? Now, I would have thought, I'm not a lawyer, Mr Parker and others are eminent lawyers around the place, I would have thought that was fraud in its simplest definition. I would have thought, no, I'm talking about if a taxpayer, absolutely, very hypothetical, I would have thought that that is fraud. If one signs a document, or signs it negligently, or falsifies documentation, or maybe has a bout of amnesia and can't remember their own name, or perhaps signs somebody else's, who knows, but can't remember doing it, would that absolve them from their tax obligations under section 1041, A, small I. Then we come to number 2. They must retain an electronic form meeting the requirements of section 25 Electronic Transaction Acts 202 for a period of 7 years at the end of the income year to which the return relates. And then you turn to 105B, C, and into 106. Exceptions to the requirement for return of income. A natural person is not required to furnish a return of income for the tax year if the corresponding income year person derives no assessable income other than, we turn the page, income of the type referred to, including a total of $200, blah, blah, blah. So there are a whole series of requirements here that require a high price and a high requirement from the individual taxpayer. 1, that they don't have amnesia. 2, that they're being honest and not fraudulent. 3, that they actually read the documentation unless they've entrusted it to a trusted advisor. And 4, that they sign their name to it. And 5, that they retain it. And presumably the Minister can advise us that the law would state that assuming you've signed it yourself, you're aware of its contents and therefore you are responsible for the veracity and accuracy of those contents. And I know the Chairman, I see the look on his face, he's taking great interest in this. I think as a former alumni of FEC, possibly, sir. But we could call this the John Banks series of clauses. And I think it's important, given the environment we find ourselves floating around in this chamber, that we get it squarely on the record whether this would be considered fraud, whether a person in that situation would have been seen as to have lied to the revenue, to have falsified documents or to have falsified the position, and that being the case, what penalties or remedies would the revenue have through our judicial system? Because it is a worry, and the other point is, I presume under the Mental Health Act there is some power of attorney would be required if somebody didn't have the mental capacity to sign, I'm being very serious, to sign their own name because, for instance, they had amnesia. So presumably, oh no, it is in scope. Because in order to comply with 104, presumably you would have to delegate power of attorney to somebody of sound mind who could sign on your behalf. But presumably a court would hold that you would have to the court would have to determine whether you indeed perhaps did have amnesia, were incapable of remembering your own name or acting as a responsible citizen, therefore required power of attorney to be delegated to a third party. Now that might happen, and if that was the case, presumably you'd comply with the law. But if you falsified the documentation, the question, I know the Minister and the Chair is a lawyer, a very senior lawyer, I'm told, so she will be able to snap her fingers and gain the answer for us to this. What are the penalties? what are the remedies that the Revenue would have under that theoretical case if the documents were not retained under 104 and they were not signed appropriately. I think this is something I know Mr Bridges, as a former chair of FEC, this is an issue very close to his heart, that and wheel clamping as Associate Transport Minister. He asked me if I'd mention him in the speech tonight. We call him Jed Clampett for obvious reasons. He is famous for his role as Associate Finance Minister.
Dr. Rajan Prasad.
Thank you, Mr Chairman. It's